Hi, and welcome back to Sociology of Law. Today we're going to continue with our topic of the week, case structure, and how case structure affects the handling of legal cases. And we're going to move on to the topic of social stratification. So in the last topic, we talked about how the social status of the people involved in a legal case is one key element of the case's social structure. And we talked about how law increases with social status, meaning that cases between higher status people are more likely to get reported to the legal system, and the legal system is more likely to take them seriously, and they're more likely to result in legal action and punishment at every phase of the legal process. Cases between lower status people, on the other hand, less likely to result in legal intervention, including calls to the police, arrests, lawsuits, and punishments. But when we talked about the effects of social status, we were assuming cases in which the parties are roughly of the same status. They're roughly equal. But you also get plenty of cases in which the parties are not equal. This is social stratification, also called social inequality, where the parties involved have different levels of social status. One is rich, one is poor. One's an organization, one's an individual. One has a sterling reputation, the other is a notorious deviant. All these are examples of a stratified type of legal case. And before we talk about the impact of social stratification, we need to introduce a new concept here, and that's the concept of the direction of law. So social structure of a case includes not just the overall degree of status or inequality within the case, but also the direction in which law is moving. And to understand direction of law, you think of this in terms of who complains against whom. Legal cases start as social conflicts. Somebody thinks somebody else has done something wrong or deviant, and they file a complaint about this. And so the party with the complaint, the alleged victim, the person who calls the cops or files a lawsuit, has a grievance, a complaint against another person or group. And so this grievance or complaint has a direction, moving from one person to another, or one group to another, from the alleged victim to the alleged deviant. And if we think of this in terms of legal cases, the direction of law follows the direction of this complaint. When somebody calls the police on somebody else or files a lawsuit against somebody else, they're mobilizing law against somebody else. They're pointing the law at somebody else and saying, go get him. So the direction of law is the direction of the complaint. It flows from the victim or plaintiff, if it's a civil case, to the defendant. So when we speak of direction, we speak of the direction from the victim or plaintiff towards the defendant. And you can also think about this in criminal cases as being opposite to the direction of the alleged offense. So if somebody robs or kills another person, the direction of law, when law comes in to punish somebody for robbing and killing that person, is opposite to the direction of the offense, because law is seeking to punish somebody on behalf of that person. It's taking up their cause and their grievance and their complaint. And this is all relevant to understanding the role of social inequality, because whether the direction is going from a rich person to a poor person or from a poor person to a rich person matters. So here the relevant pattern, the general theory of law, is that downward law is greater than upward law, meaning that cases in which the law is being mobilized by a higher status person against a lower status person tend to attract more law than the reverse. Likewise, cases in which the law is operating on behalf of a higher status person who's allegedly been victimized by a lower status person tend to produce more law than the reverse. So when low status people have complaints, grievances against higher status people, law is they're less likely to bring this complaint to the legal system in the first place. They're less likely to call the police or file a lawsuit if the person they have a complaint about is much wealthier than themselves, much more reputable than themselves, much more educated and integrated than themselves. If it's a powerful corporation and they're a lone individual, this makes them less likely to turn to law. And if they do turn to law, law is less likely to respond to them. If homeless Joe calls the police on the local respected businessman or the mayor or somebody else of high status, the police are less likely to handle the complaint the way homeless Joe wants, less likely to make an arrest, less likely to bring the case before the magistrate or prosecutor. And for their part, the magistrate, the prosecutor, the court clerk, they'll also be more likely to dismiss the case, less likely to bring a severe charge. Juries and judges are less likely to side with homeless Joe against the mayor or the respected wealthy businessman. But in the other direction, when you have a higher status person, someone wealthy, integrated, respected, or a powerful organization, complaining against somebody of lower status, someone poor, disreputable, somebody who is a member of the cultural minority or less educated, they tend to be more successful. They're more likely to call the police in the first place or to file lawsuits in the first place, and the legal system is going to be more responsive to their complaints. more likely to intervene, and more likely to intervene on their behalf. So the thing about inequality of status is that it's variable. You could have somebody who's just a little bit superior to you, just a little bit wealthier, just a little bit more integrated, just a little bit more educated. And you could have somebody who's just a little bit below you, just a little bit poorer, just a little bit less educated, just a little bit more of a record of deviance. And this too affects the quantity of law. And the basic pattern here is that as the differences grow larger, as the degree of inequality, the degree of difference in status increases, the effect that it has on upward versus downward cases increases. Or to put it as Black does, in a downward direction, law increases with vertical distance. That is, the farther the distance between the victim or plaintiff and the defendant, between the person who complains and the person who's the target of their complaint, the greater the disparity in status between them, the greater the quantity of law is likely to be. So a complaint against somebody just a little bit lower in the status structure is less likely to result in arrest or a trial or a harsh punishment than a complaint against somebody substantially lower in the status structure, which in turn is less likely to result in arrest or trial or punishment than a complaint against somebody very far down in the status structure. The greater the disparity, the greater the distance law is traveling downwardly, the more severe law is likely to be. On the other hand, in an upward direction, it's the opposite. In an upward direction, law decreases with vertical distance, meaning that a case against somebody who's just a little bit superior is more likely to succeed than a case against somebody who's substantially superior, and still less likely to succeed is a case against somebody who's very distantly superior. For example, a powerful organization, perhaps even the government of the nation itself. Another way of understanding this pattern is to think about it in terms of the difference between upward and downward law is most extreme in places where the status differences are most extreme. And you see these kinds of cases in, say, societies that practice slavery, which is something that's been done around the world throughout history in many societies, including in America before the Civil War. And you have this distinction between the slave-owning class, who are typically the wealthier people in society already, who own plantations and other sorts of large estates, and the slaves who are property themselves and unable to own property often, who have no legal rights, no education, and are considered disreputable by the free men in society, almost deviant by their very existence. And downward offenses by masters, by freemen against the slaves, are largely tolerated, as long as you're not messing up someone else's slave, in which case it's more like an offense against the master, you're destroying his property. As long as you're damaging your own slaves, it's often not even a crime. And of course, whipping slaves and other forms of brutal punishment is accepted and normal in societies where slavery is practiced. And in most societies where slavery is practiced, killing a slave is not even, legally speaking, a crime. Slaves themselves have little legal recourse or right. An American slave couldn't very well file lawsuits against the plantation owner. In ancient Rome, if a slave accused a freeman of a crime, this was itself a crime. Using the law was literally illegal for a slave. Upward law to them was completely forbidden. On the other hand, upward offenses by slaves against the masters, or the freemen, were punished very severely. In ancient Rome, a slave who rebelled or disobeyed his or her master could be sentenced to die in the arena being eaten by wild animals, a particularly gruesome and frightening death. In New York, in 1741, a dozen slaves were accused and convicted of a conspiracy to rebel, and their punishment was to be burned at the stake. Law moving downwardly towards people at the bottom of society on behalf of people at the top of society can be very, very harsh. So let's combine these ideas we've talked about in the past two topics. We've had this effect of the social status of the case, whether the people involved are generally high status or low status. We have this effect of the vertical direction of the case. Is it going upward or downward? Now, combine these two effects and you'll get a fourfold pattern. And Black predicts that the probability of law should vary across these combinations, with the least law when a low-status person complains against high, and the most when a high-status person complains against low. And the second lowest amount of law should be when a low-status person complains against a fellow low-status person, and the second highest amount of law should be when a high-status person complains against a high-status person. One piece of data you can turn to illustrate this pattern in the modern world is the application of the death penalty, specifically looking at racial differences in the death penalty. And you'll notice we haven't talked about race as such, because we're using this abstract characteristic status, and skin color is not inherently a kind of status, but it so happens that in modern America it's tightly correlated with status. Blacks on average have much lower wealth and less education, and are more likely to have criminal records. So blacks on average are lower in status than whites in America. That's been the dominant pattern since the days of slavery. And so you can use race as a rough measure of social status. And if we look at race and the death penalty, if we just look at the race of the killer, we might find that there's little or no difference, that black killers and white killers get sentenced to death at about the same probability. But that's because race of killer hides an important variable, and that's race of the victim. The important thing in the sociology of law isn't just to look at the status characteristics of the victim or the offender, but to look at the combination of both. When you look at the combination of both, you see a fourfold pattern that closely maps onto what Black predicts. So the statistics I'm showing in the slide are from an older study from 1980, and I just picked this chart because it happens to look clear and show the pattern very neatly. But you can look at more recent studies using all kinds of more sophisticated methods, and they find the same pattern has largely persisted over the decades. And so the highest probability of a death sentence occurs when a black offender is convicted of killing a white victim, and the lowest probability of a death sentence occurs when a white offender is convicted of killing a black victim. And in between, we see that whites who kill white victims actually have a higher probability of getting the death sentence than blacks who kill black victims, which is one reason that when you just look at race of offender, the pattern's not clear. Depending on how many cases there are of whites killing whites, white people might actually have a higher probability of the death sentence in any particular state. But if you break down the pattern by relationship between offender and victim, you see that upward killings do in fact get the death penalty more than downward killings, and high status killings get the death penalty more than low status killings.